Hello, my name is Ian Larkins of Brady's Law, and welcome to our first monthly commercial legal bulletin, brought to you in association with LexisNexis. In just 15 minutes, we'll keep you abreast of the big commercial legal news stories. So grab a cup of tea, relax, and allow us to keep you effortlessly updated with the information that your business can't afford to miss. First up, data protection. There have been a couple of stark warnings to employees tempted to breach data privacy rights. In August, it was reported the Information Commissioner's Office, the ICO, had fined a banker £880 for snooping on a colleague's bank account. The employee, who had access to view customer bank accounts in his money laundering investigating role, allowed curiosity to get the better of him, and he looked at some of his colleagues' bank accounts for salary and bonus information. In another case, a paralegal has been prosecuted for illegally taking sensitive personal data from his employer, hoping to use the data in a new role. These cases underscore the need for good data protection training, and particularly highlighting that individuals can be personally prosecuted for data protection offences. Other data protection matters recently hitting the headlines include the ICO issuing new guidance on data protection and the media. This follows an order by the Leveson inquiry. The ICO has served a £180,000 monetary penalty notice against the Ministry of Justice following the loss of a portable backup drive containing sensitive material of almost 3,000 prisoners. The drive was not password protected and nor was it encrypted. The case was deemed even more serious as there had been a similar incident in 2011, but little remedial action had been implemented. John Lewis has become the first company entangled in a court case where the direct marketing laws have been fully debated. It is understood that the claimant complained about receiving emails stating that they were sent in breach of privacy and electronic communications regulations. These regulations require that consumers have opted in before marketing emails are sent. There is an exception to the positive opt-in known as the soft opt-in, essentially a pre-tick box, to make it easier for organisations to send electronic marketing to existing customers. It is understood that John Lewis sought to rely on this exception, but failed as the claimant did not meet the narrow requirements, particularly that he had not previously purchased anything. This case highlights the need for businesses to review their personal data collection processes and ensure that they are compliant with these regulations. An ICO audit report of 16 local authorities has recently been published, reporting that none of the authorities were able to demonstrate a high assurance of data protection compliance. 6 were rated as limited assurance and 1 as a very limited assurance. The Advertising Standards Authority, the ASA, has announced its new strategy. Until now, the ASA has been reactive. No complaints have meant no investigation. But just one complaint has led to a full investigation. The ASA has now promised a more targeted approach. In short, those in the prioritised sectors can expect more attention, whilst others may feel the heat is off them for a while. Undoubtedly, the prioritised sectors will change depending on public mood. Facebook is making significant changes to its terms, which will take effect from the 5th of November this year, and will have an impact on organisations that use Facebook for advertising and sales promotions. The main change is that Facebook owners will no longer be permitted to require Facebook users to like a page to gain access to Facebook app content, e.g. to enter a promotion or a competition or download an ebook. This practice is known as like gating and has been a common way for pages to increase their number of likes. In a recent case, the defendant was unable to rely on its terms and conditions that included, amongst other things, a choice of court. In this case, the claimant had stated that only the front page of the documents had been sent to them, and the defendant was unable to evidence otherwise. This case is an illustrative reminder of the need for good processes to ensure that terms and conditions are brought to the attention of the other party. It's of course particularly easy to neglect to include the terms and conditions on the reverse of documents when contracting by clients. In another case, it was reported that the business had been duped out of over £200,000 by being provided with the wrong chap's payment details, and have no recourse against the bank. It appears that the fraudster had provided a sort and account number that did not correspond with the payee name. But in line with established banking practices, the bank only checked the account and sort code number. We suspect that most businesses are unaware of the lack of banking checks for CHAPS payments and urge all businesses to review their own payment controls. A recent Scottish Employment Appeals Tribunal case held that generally time on call is working time if it is spent in a place that is determined by the employer, and therefore the employee is entitled to have time on call included when calculating average working weekly hours. In this case, the claimants were employed as relief ambulance paramedics and had to stay within 3 miles of the ambulance station, had to keep an ambulance with them, and had a 3-minute target mobilisation time. Continuing on a similar theme is a case reported a little earlier this year concerning whether an employee that has a variable element of his or her pay, typically for commission pay, can include the average of the commission earned for the purposes of calculating holiday pay. The European Court of Justice in this case determined that yes, a sum representing the commission should be included for the pay during the holiday. Commission payments are, of course, regular practice in most sales functions, and if this is relevant to your business, it will make good sense to review your holiday payment policies. The draft Statutory Shared Parental Pay General Regulations of 2014 have now been implemented and provide for a new entitlement for mothers, fathers, or partners of mothers who are employed earners, and for adopters and their partners who are employed earners, to receive a statutory payment from their employers called the Statutory Shared Parental Pay. Eligible employees will be able to share up to 50 weeks of shared parental leave and up to 37 weeks of statutory parental pay. The law surrounding contracts formed at a consumer's home was tested in a recent case. Here, the seller refused to refund a deposit after the consumer had cancelled the contract. Technical issues were aired in the case, particularly where the consumer's cancellation rights was defeated by the fact that the seller had not issued a cancellation notice. The seller had also argued that the cancellation regulations did not apply when there had been repeated home visits. The Court of Appeal ruled against the seller on both counts. What should businesses take from this? Well, with limited exceptions, if you are contracting with a consumer made other than during a visit to your trade premises, then there is a 14-day right to cancel. If no notice is given, then the cancellation right is extended to 1 year. Following concerns that consumers have been unable to get redress for misleading and aggressive practices, consumers will be able to seek redress by private court actions under the amended Consumer Protection Regulations. The new rights are effective from the 1st of October. 4 former executives of the British company Inspec have been sentenced for their roles in bribing state officials in Iraq. The case was brought under the Bribery Act, and sentences range from 4 years in prison to a 16-month suspended sentence with 300 hours of unpaid work. This case proves that the SFO is making headway in prosecution under the Bribery Act, and it also has a much publicised pipeline of cases. Director of the SFO, David Green, recently reported that he continues to focus on top-level fraud and bribery, and reported that he has a 10% increase in funding and additional Treasury blockbuster funding for exceptional cases. Green is also calling for a change in the law and is seeking to persuade Parliament to impose a liability on companies that fail to prevent acts of financial crime by its associated persons. This is no surprise when most of the pipeline of the SFO cases involve incidents of agents, facilitators and subsidiaries causing a headache for their parent companies. The lesson here is to make sure that your compliance plan extends to good due diligence checks on any business partners that represent you. The Financial Reporting Council has issued an updated version of the UK Corporate Governance Code and is applicable for accounting periods beginning on or after the 1st of October 2014. Whilst this code is only applicable for some listed businesses, it is nevertheless advisable to review the code and apply it to your business where appropriate. It includes changes to remuneration with the aim to encourage companies to align with rewards with the sustained creation of value, risk management and internal control. The Companies House has issued new guidance which emphasises that failure to deliver documents on time is a criminal offence with potentially unlimited fines. Fines can be levied personally against any member of an LLP or director of a limited company. Whilst we suspect that criminal actions and severe fines will be reserved for the most serious cases, it is a warning to companies that regularly miss filing deadlines. Following the payday lender Wonga revelation, in June this year they sent letters to customers in arrears from non-existent law firms. It's become apparent that many other financial institutions have in-house brands that give the outward appearance of being an external law firm. The Solicitors Regulation Authority has issued a warning to solicitors following this activity coming to light and highlighting the obligations on all solicitors to act with integrity and to behave in a way that maintains the trust the public places in the provision of legal services. The FCA has published a guidance consultation on social media and customer communication by regulated financial institutions. There is no particular surprise in the material which focuses on the requirement under Principle 7 to communicate with customers in a way that is clear, fair and not misleading. There are of course inevitable constraints with character limitation in some forms of social media. The consultation documents suggest some practical measures for still meeting the FCA requirements. And finally, the monkey that took a picture of himself has caused much legal debate. It is well known that copyright, unless assigned, is owned by the creator. A photograph would therefore belong to the photographer, but where the photographer is not a legal person, i.e. a monkey, then it's unclear who owns the copyright. This issue came to light after it was reported that the photographer was considering legal action against Wikimedia for refusing to take down a selfie of the monkey. Wikimedia had responded saying that as the photograph was taken by a monkey, there is no copyright and is therefore in the public domain. This case is unresolved but does serve as a stark reminder about the risks of using material that's been posted on the web. Thanks for joining us for our first commercial law update. This videocast and podcast are available and downloadable from the LexisNexis blog. You'll also find a written report there too. The website details of LexisNexis and Radius Law will be shown on your screen in a moment. Thank you and goodbye.